what constitutes a misrepresentation? The Supreme Court in Santa Fe Industries, Inc. versus Green held there can be no violation of Section 10B or 10B5 without any deception, misrepresentation, or non-disclosure. Therefore, it is a paragraph B of 10B5 that does the work in litigation under the anti-fraud provision among Rule 10B-5's 3 prescriptions. It is paragraph B that most clearly reflects Santa Fe Industries holding as it prescribes material misstatements and omissions made in connection with the purchase or sale of a security. Misstatements are fairly easy to identify. For example, if a company announces it earned $3 per share in the most recent quarter when in fact it earned substantially less than that amount, it has engaged in a misstatement. Rule 10b-5's prescription of material misstatements can be seen as requiring that when an affirmative statement is made, what is affirmatively stated should be correct, subject to other requirements of the rule, such as materiality, being in connection with the purchase or sale of a security, etc. Omissions are also prescribed, but with the qualification that the omitted fact is not just material, but needed to be disclosed in order to make the statement made in light of the circumstances under which the statement were made not misleading. To be observed here is that a material of which where was I? I don't even know. I must have skipped a line or something. In order to make, so just starting with the quote again. No, starting with omissions are also prescribed, but with the qualification that the omitted fact is not just material, but needed to be disclosed in order to make the statements made in light of the circumstances under which they were made not misleading. To be observed here is that the materiality of the omitted fact itself does not render an omission of that fact a violation. A violation ensues only if that omitted fact renders what was disclosed materially misleading. Thus, when dealing with an omission, courts focus on whether the defendant had a duty to disclose the omitted material fact. Such violations are generally referred to either an omission or duty to disclose cases. Duty to speak. By way of background, consider the 3 models that government regulation of disclosure might take. First, as we have seen, the Securities Exchange Act imposes on certain companies a duty of periodic disclosure in a form of annual Form 10-K and quarterly Form 10-Q reporting requirements. Second, the disclosure can be mandated for discrete transactions or activities. Such transactional disclosure occurs today for the public offerings of securities, the election of directors, or other matters involving the approval of shareholders of public companies. Finally, there is a somewhat utopian world of continuous disclosure where companies must disclose material information as soon as material information arises. This form of disclosure is pretty much limited in the United States to the rather tightly configured mandates of Form 8K for public companies. There is limited evidence of continuous disclosure. To be sure, in the post-Enron era of financial frauds, Form 8K was greatly expanded. However, Form 8K still compels disclosure upon the occurrence of specified events, entering into or discontinuing a material transaction. That's not right. So what are those events again? 8K compels disclosure upon the occurrence of specified events, entering into or discontinuing a material transaction outside the ordinary course of operations, the resignation of a firm's outside auditor, or the departure of director of a reporting company. In addition, the stock exchange listing requirements set forth certain duties to disclose important developments and events through. Although typically the only sanction for non-compliance with those rules would be delisting, and that sanction has seldom or never been imposed for mere non-disclosure. Also, absent a specific SEC disclosure requirement that needs to be met, such as the pending Form 10-K, there generally is a good deal of discretion on the part of the company's management. As a leading case on this point, emphasize the timing of the disclosure of material facts is a matter for business judgment of the corporate officers entrusted with the management of the corporation within the affirmative disclosure requirements promulgated by the exchanges and by the SEC. From SEC versus Texas Sulphur Company, CERT denied. There are 4 important instances courts regularly find a duty to hold material information. Half-truth statements. A common ground for alleging fraud occurred by non-occurrence is the instance of a half-truth. Recall that Rule 10b-5 includes among its prohibitions an omission to state a material fact necessary in order to make the statements made in the light of the circumstance under which they were made not misleading. So that's a definition of omission. Like, make that very clear. To state a material fact, this is the definition of omission. Necessary in order to make the statements made in light of the circumstances in which they're made not misleading. So, thus, a duty to disclose can flow from omitting a fact that was necessary to prevent what was stated being materially misleading. For example, Twitter committed a misrep when it announced continued growth in the total number of users of its service, but did not disclose that average daily use had declined. In light of the fact that average daily use was found to be important by stock analysts. Shenwick versus Twitter Inc. See Donald C. Langevort, Half-Truths, Protecting Mistaken Inferences by Investors and Others. I feel like that question matters more how it was said. That whether or not that's relevant. Like, was it set forth in something meant to be disseminated among investors? Or was it just like a stat on the news? Like, I think that's going to be an impossible standard to set. Duty to correct. If the corporation makes a statement that is misleading and inaccurate when made, even though not intentionally or recklessly so, and the corporation learns later that the statement was misleading, it is under a duty to correct the statement if the statement is still alive rather than stale. That is, if the statement would be likely to be material to investors. See example, Backman v. Polaroid Corp. And Bank in re Burlington Coat Factory SEC litigation. 3rd Circuit, 1997, explains the duty as follows. The duty to correct can also apply to a certain narrow set of forward-looking statements. We will attempt to illustrate the kinds of circumstances we have in mind when with an example. Imagine the following situation. A public company in Manhattan makes a forecast that appears to it to be reasonable at the time made. Subsequently, the company discovers that it misread a vital piece of data that went into its forecast. Perhaps a fax sent by a company's factory manager in some remote location was blurry and was reasonably misread by management in Manhattan as representing sales for the past quarter as 100,000 units as opposed to 10,000 units. Manhattan management then makes an erroneous forecast based on the information it has at the time. A few weeks later, management received a correct sales figure by mail. So long as the correction in the sales figures was material to the forecast that was discussed earlier, we think there would be a duty on the part of the company to disclose either the corrected figures or a corrected forecast. In other words, there is an implicit representation in any forecast or statement of historical fact that errors of the type we have identified will be corrected. This duty derives from the implicit factual representation that a public company makes whenever it makes a forecast, i.e., that forecast was reasonable at the time made. What is crucial to recognize is that the error, albeit an honest one, was one that had to do with information available at the time the forecast was made, and that the error in the information was subsequently discovered. 3, duty to update. A more difficult question is whether a corporation has a duty to update an earlier forward-looking statement that comes to be materially misleading. Several courts have held that if a corporation makes a public statement that it corrects when made, but that corporation may have a duty to update the statement. For example, in Greenfield v. Hubline, Inc., cert denied, the court said, although a corporation may be under no duty to disclose, if a corporation voluntarily makes a public statement that is correct when issued, the corporation has a duty to update the statement if it becomes materially misleading in light of subsequent events. See also, in Time Warner, Inc., Securities Litigation cert denied. A duty to update opinions and projections may arise if the original opinions or projections have become misleading as a result of intervening events. Insider trading. As examined fully in the next chapter, insiders who trade on or selectively disclose to others material non-public information violate the anti-fraud provision. This occurs under the so-called disclosure abstain doctrine when in possession of material non-public information or disclose that information. Hence, insider trading regulation has its own mechanism for imposing a duty to disclose. Entanglement. A corporation may so involve itself in the preparation of statements about the corporation by outsiders, such as analyst reports or earnings projections, that it assumes a duty to correct materials. That's really interesting in those statements. Such a duty may occur when the officials of the company have, by their activity, made an implied representation that the information they reviewed is true, or at least in accordance with the company's views. Elkine v. Liggett and Myers, Inc., duty to correct erroneous rumors resulting from leaks by the corporation or its agents. See example, State Teachers Retirement Board v. Floor Corp., dictum 1981. Opinion statements, which is part B, coming before forward statements, before we get to the materiality prong. So, Rule 10b-5 speaks in terms of misstatements or omissions of a material fact. A perplexing question is whether an expression of opinion is a fact. At many locations, the SEC's mandatory disclosure rules call for corporations and their senior executives to provide opinions regarding certain matters. More frequently, public statements regarding corporate transactions or developments are statements of opinion. Omnicare, Inc. versus Labor vs. District Council Construction Industry Pension Fund doesn't have a date. It doesn't have a citation, but the date is 2015, illustrates the court's approaches to such statements. In that case, Omnicare, Inc. made 2 statements regarding the compliance program, stating it believed its arrangement with suppliers and customers were in compliance with their state and federal law. And adding that they were legal arrangements, they were not in compliance, and a securities fraud was brought after its unlawful practices caused in stock price to decline. Justice Kagan examined how the statements could be actionable both as a misstatement and omission of material facts. The claim of compliance can be a misstatement if the speaker doesn't actually believe the opinion stated, i.e., the speaker knows the company's arrangements and contracts with the customers and vendors are not lawful. A company CEO states, TVs we manufacture have the highest resolution available on the market, or alternatively, the CEO transforms that factual statement into a one of an opinion. I believe, or I think, the TVs we manufacture have the highest resolution available on the market. The first version would be an untrue statement of fact if the competitor has introduced a higher resolution TV a month before, even assuming the CEO had not yet learned of the new product. The CEO's assertion, after all, is on mere puffery, but a determinable, verifiable statement about her company's TVs, and the CEO, however innocently, is wrong. Got the facts wrong. But in the same circumstances, the second version would remain true. Just as she said, the CEO really did believe when she made the statement that her company's TVs had the sharpest picture around. And although a plaintiff could later prove the opinion erroneous, the words "I believe" themselves admitted that possibility, thus precluding liability for an untrue statement of fact. That remains the case if the CEO's opinion, as here, concerned legal compliance. If, for example, she said, "I believe our marketing practices are lawful," and actually did think that she could not be liable for a false statement of fact, or even if she afterward discovered a long-time violation of law. Once again, the statement would have been true because all she expressed as a view, not a certainty about legal compliance. As even Omnicare acknowledges, every such statement explicitly affirms one fact, that the speaker actually holds a stated belief. For that reason, the CEO statement about product quality, "I believe our TVs have the highest resolution available on the market," would be an untrue statement if of fact, namely the fact of her own belief, if she knew that her company's TVs only placed second. And so too the statement about legal compliance, "I believe our marketing practices are lawful," would falsely describe her own state of mind if she thought her company was breaking the law. A statement of opinion can also be actionable fact on the ground it omitted certain facts needed to prevent what was said from being materially misleading. An investor cannot state a claim by alleging only that an opinion was wrong. The complaint must, as we call into question, the issuer's basis for offering the opinion. To be specific, the investor must identify particular and material facts going to the basis for the issuer's opinion, facts about the inquiry the issuer did or did not conduct, or the knowledge it did or did not have, whose omission makes the opinion statement as at issue misleading to a reasonable person reading the statement fairly and in context. Thus, if at the time of making the claim of compliance with the law, the speaker was aware the firm's general counsel had warned that some of the arrangements as violating certain state and federal requirements that could give rise to misrepresentation of opinion. But the court observed this is tricky as it expressed doubt that there would have been a misrepresentation if the warning had come from a very junior attorney. Forward-looking statements, Part C. A universal quality about the future is that it is hard to predict accurately. When a company estimates that it will earn $3 in the next year and ultimately earns materially less, it was earlier statement materially misleading. What would render the statement actionable under Rule 10b-5? Are there risks that a determination of fault will be made via hindsight so that earlier assumptions in formulating the forecast will be viewed differently by the trier of fact? For example, what if the earlier prediction assumed that materials and labor costs would not rise, but in retrospect, the assumption appears grossly optimistic? See Financial Industrial Fund versus McDonald Corp. of the 10th Circuit of 1973. 1. Statutory safe harbor for forward-looking statements. In 1995, with the enactment of the Private Security Litigation Reform Act, discussed more fully later in this chapter, Congress provided safe harbors in the Securities Act for most forward-looking statements, that is, statements about the future, for example, predictions of earnings. Section 21E C1 provides two safe harbors against civil liability for written forward-looking statements as defined that are one, made by a corporation that either has security registered under Section 12 of the Act or has filed a registration statement as described in Section 15B, or two, by certain persons acting on behalf of such a corporation. So those are the people protected. Under the first safe harbor, there is no liability if the statement is identified as a forward-looking statement and is accompanied by meaningful cautionary statements. Identifying important factors that could cause actual results to differ materially from the statement. Under the second safe harbor, there is no liability if the plaintiff fails to prove that the statement was made with actual knowledge, not simply with recklessness, that the statement was false or misleading. So the plaintiff has to prove that. Accordingly, Section 21E eliminates recklessness as sufficient scienter under Rule 10b-5 for forward-looking statements, although it does not affect omissions or statements that purport to concern historical or existing facts or forward-looking statements expressly excluded from the Section 21E safe harbor. Section 21EC2 provides a special additional safe harbor applicable only to oral statements, comparable provisions found in the SEC. So this is oral statement safe harbor number 3. Bespeaks caution doctrine. Independent of the statutory safe harbor is a doctrine known as bespeaks caution that provides that it's another safe harbor. Forward-looking statement does not give rise to reliability, even though, if taken in isolation, it is misleading if the document in which a statement is contained includes meaningful cautionary language. This is crazy. Like, why don't they teach this This is something compliance needs to know, not just lawyers. The applicability of the bespeaks caution doctrine is highly fact-specific. To some extent, it is also court-specific. Different circuits have been either more or less ready to conclude that cautionary language is sufficient to protect against liability. It's fairly clear, however, that a generic boilerplate warning will not suffice. To have the desired effect, the cautionary language must be tailored the specific future projections, estimates, or opinions which the plaintiffs challenge. And then it cites a Trump's casino securities litigation case in the Third Circuit, 1993, Gallup versus Trump, 1994. By its terms, the bespeaks caution doctrine, like the safe harbor provisions in so not boilerplate. Like, what is what could this possibly be? I need an example besides just the case name. Like the safe harbor provisions in Section 21E, it is directed only to forward-looking statements, not to the statements of historical facts, present facts. Either the doctrine of its is of special relevance when a forward-looking statement is made by a corporation or other person who is not within the safe harbor provided by Securities Exchange Act Section 21E, because the statement was made in the context of one of the many exceptions in Section 21E. For example, a corporation that does not have a class of stock registered under Section 12, the statement was made in connection with the initial public offering or the statement was made in connection with a tender offer. Are these exceptions? Is the tender offer initial public offering? I mean, it makes sense that they would be. I just didn't know that from my last reading. So materiality begins with a case, Basic Inc. versus Levison, which is an important case. It's like 4 pages long, and I just don't have the time for it right now, so I'm going to start that section later.